Hi, I'm Catherine Tremblay. I started the company nearly 29 years ago at the age of 21, and believe me, I've learned a few things along the way about employment agreements. I'm sharing my experience today with you in this video. In my opinion, it's better to have a signed agreement than not have one, because it sets out the terms of your employment relationship and may protect you as an employer or protect the employee should there be a dispute or possibly the need for termination later on down the road. Now, the disadvantage of having a written and signed agreement is that it does make it harder for you to change the terms of your agreement. If you do make a significant change to the employee's arrangements, you must offer consideration to have a new agreement considered and signed. Consideration means that you have to give something to get something. For example, if you wish to change the employee's work location, you would offer an enticement such as a promotion, a salary increase, or a signing bonus. I know you probably dislike the technical elements that are found within your employment agreement, all that legalese and words like herein and thereof, but these terms are part of everyone's employment agreements. Any decent employment contract doesn't sound that friendly if you ask me. Now, to make your employment agreement valid, meaning it could be argued in court successfully, here are a few tips. Number one, from the date that you make your employment offer to when it is accepted, that means it's been signed and returned, you should ideally allow 7 calendar days or 5 business days. The reason? If you make an offer today and it's signed today, the employee did not have sufficient time to seek independent legal advice. If the contract is ever disputed and the employee was not given the time to seek legal advice, then the whole contract could be invalid. If you must have an employee start right away, give them the offer as quickly as possible and allow 3 business days from signing to start. Never allow your prospective employee to sign the agreement right in front of you on the spot. It will invalidate the agreement. Number 2, next tip. The date on the top of the agreement should be the same date that you are actually giving the employee the contract. You can't backdate the contract, and you don't want tomorrow's date, for the same reason as in number 1. Dates matter in employment contracts. Judges and labor lawyers will look at these dates. Number 3, I would not let the employee start their job with you without signing their employment agreement. Otherwise, they may sign it once they've already started, and that may invalidate the contract as well, because if they didn't sign, they would then have to quit, which is like having the person sign under duress. Sign it or quit. If the employee is already working with you and they are expected to sign a contract, you have to offer fresh consideration for the agreement to be enforceable. Remember that just because they get to continue their employment, that is not considered consideration. If you have someone already working with no contract and you give them one to sign, you would likely offer a signing bonus, for example, $1,000. Number 4, perhaps there are several issues or challenges in your negotiation with the prospective employee. When this happens, document the terms of your negotiation and keep the notes in your records. You could archive an email to yourself so that you have knowledge of what was agreed upon. Years later, an employee may state that they understood something completely different from what they signed. Your notes may come in handy. Number 5, the employer should always sign the contract before giving it to the employee. In other words, the employer would sign the contract and date it the same day that is on the first page. That way, you can always prove they had time to get independent legal advice. Number 6, contracts may become obsolete, in particular if the terms of the initial agreement have changed. An employment agreement may not be enforceable if the reality of the employment relationship has changed so much over time that it's no longer the same. For example, if the employee's role has changed or they are working in a different location. This is not about the length of employment that would make the agreement obsolete. It's about the changes in responsibility or location. Further, if you transfer an employee from one company entity to another, even within the same family of companies, you will wish to issue a new employment agreement with consideration, for example, the signing bonus. Number 7, you could add language to your agreement to prevent it from becoming obsolete. You would state, for example, that even if the employee's position, salary, title, location, if any of those things change, the terms of the agreement will govern all parties. Number 8, in your agreement, you'll include the obvious things such as start date, title, responsibilities, compensation, and vacation. Be sure to always include termination provisions. This is the section where the employer can protect themselves and save on costs if a dismissal is to occur. According to Employment Law 101, 30% of Ontario employment agreements have termination clauses that are not enforceable. The termination clause will normally set out how termination will be calculated and spell out what benefits and commissions will be available or continued during the notice or termination period. Remember that termination provisions cannot be less than the minimum statutory entitlements under the laws of your province. Number 9, include a confidentiality clause stating what information is confidential and proprietary to your business. Be sure that this element of the agreement is signed independently. In other words, have the employee sign a confidentiality agreement that is independent of the global agreement. Number 10, I'd also like to suggest your agreement include a social media policy, so you have something to refer to if your employee makes poor decisions on what they post on Facebook, Instagram, Snapchat, or any of those. Number 11, I would also include in your agreement that compensation can be changed with 60 days notice, or a reasonable time that you've agreed upon with your lawyer. And finally, for number 12, rely on legal counsel at least every 3 years to update your employment agreement. Employment laws are always changing, and you want to be sure that your offers are keeping up to date. There is a lot more to say on this subject, but these are reminders that I think all HR practitioners and managers can benefit from. Ask us for a copy of our agreement as a reference.